Good day everyone. Today we're going to discuss about the organization of the partners. In section 1, obligation of the partners among themselves. In section 2, property rights of a partner. Article 1784. A partnership begins from the moment of the execution of the contract unless it is otherwise stipulated. Article 1785. When a partnership for a fixed term or particular undertaking is continued after the termination of such term or particular undertaking without any express agreement, the rights and duties of the partners remain the same as they were at such termination, so far is consistent with the partnership at will. Article 1786. Every partner is a debtor of the partnership for whatever he may have promised to contribute thereto. Article 1787. When the capital or a part thereof which a partner is bound to contribute consists of goods, their appraisal must be made in manner prescribed in the contract of partnership, and in the absence of stipulation it shall be made by experts chosen by the partners and according to the current prices, the subsequent changes thereof being for the account of the partnership. Article 1788. A partner who undertakes to contribute a sum of money and fails to do so becomes a debtor for the interest and damages from the time he should have complied with the obligation. Article 1789. An industrial partner cannot engage in business for himself unless the partnership expressly permits him to do so, and if he should do so, the capitalist partners may either exclude him from the firm or avail themselves of the benefits which he may have obtained in violation of this provision with the right to damages in either case. Article 1790. Unless there is a stipulation to the contrary, the partner shall contribute equal shares to the capital of the partnership. Article 1791. If there is no agreement to the contrary, in case of an admitted loss of the business of the partnership, any partner who refuses to contribute additional share to the capital, except industrial partner, to save the venture shall be obliged to sell his interest to the other partners. Article 1792. If the partner authorized to manage collects a demandable sum which was owed to him in his own name from a person who owned the partnership, another sum also demandable, the sum thus collected shall be applied to the two credits in proportion to their amounts. Article 1793. A partner who has received, in whole or in part, his share of a partnership credit when the other partners have not collected theirs shall be obliged, if the debtor should thereafter become insolvent, to bring to the partnership capital what he received, even though he may have given receipt for his share only.
Article 1794. Every partner is responsible to the partnership for damages suffered by it through its fault, and he cannot compensate them with the profits and benefits which he may have earned for the partnership by his industry. Article 1795. The risk of specific and determinate things which are not fungible contributed to the partnership so that only their use and fruits may be for the common benefit shall be borne by the partner who owns them. Article 1796. The partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership and for the corresponding interest from the time the expenses are made. Article 1797. The losses and profits shall be distributed in conformity with the agreement. If only a share of each partner in the profits has been agreed upon, the share of each in the losses shall be in the same proportion. Article 1798. If the partners have agreed to entrust to a third person the designation of the share of each one in the profits and losses. Article 1799. A stipulation which excludes one or more partners from any share in the profits or losses is void. Article 1800. The partner who has been appointed manager in the articles of partnership may execute all acts of administration despite the opposition of his partners, unless he should act in bad faith. Article 1801. If two or more partners have been entrusted with the management of the partnership without a specification of their respective duties or without a stipulation that one shall. Article 1802. In case it should have been stipulated that none of the managing partners shall act without the consent of the others. Article 1803. When the manner of management has not been agreed upon, the following rules should be observed. Article 1804. Every partner may associate another person with him in his share, but associate shall not be admitted into the partnership without the consent of all the other partners, even if the partner having an associate should be a manager. Article 1805. The partnership books shall be kept, subject to any agreement between the partners, at the principal place of the business of the partnership, and every partner shall at any reasonable have access to any may inspect and copy any of them. Article 1806. Partners shall render on demand true and full information of all things affecting the partnership to any partner or the legal representative of any deceased partners or of any partner under legal disability. Article 1807. Every partner must account to the partnership for any benefit and hold as trustee for it any profits derived by him without the consent of other partners from any transaction connected with the formation, conduct, or liquidation of the partnership or from any use by him of its property. Article 1808. The capitalist partner cannot engage for their own account in any operation, which is the kind of business in which the partnership is engaged, unless there is a stipulation to the contrary. Article 1809. Any partners shall have the right to a formal account as to partnership affairs.
Section 2. Property rights of a partner. Article 1810. The property rights of a partner. First, his rights in a specific partnership property. Second, his interest in the partnership. And third, his right to participate in the management. Article 1811. A partner is co-worker with his partners on the specific partnership property. Article 1812. A partner's interest in the partnership is his share of the profits and surplus. Article 1830. A conveyance by a partner of his whole interest in the partnership does not of itself dissolve the partnership or as against the other partners in the absence of agreement. Article 1840. Without prejudice to the preferred rights of partnership creditors under Article 1827, on due application to a competent court by any judgment creditor of a partner, the court which entered the judgment or any other court may charge the interest of the debtor partner with payment of the unsatisfied amount of such judgment, the interest thereof, and may then or later appoint a receiver of his share of the profits and of any other money due or to full due to him in respect of the partnership, and make all other orders, directions, accounts, and inquiries which debtor partner might have made or which the circumstances may require. Examples of cases from different articles. First is the Article 1786. So Maria promised to contribute land to the Irenic partnership. The land is located near the office premises, thus an ideal location to build a fast food restaurant. Agreed date of delivery of the land is on or before June 30, 2020. So in first scenario, if after June 30, 2020, Maria failed to deliver the said land to the partnership, Maria automatically becomes a debtor of the partnership even in the absence of the grant. The second scenario is Maria complied the said date of delivery and the operation started after 2 months. If After 6 months, brother of Maria came and claiming that the land was his and not of Maria, Maria then became liable to the partnership. The third scenario, in the above example, let's say Maria agreed to contribute land and building to 2020. The building was on fire. Because of the fire, the building can no longer used by the partnership. So the second example is the Article 1789. So Nana and Mia form a partnership that engage in music tutorial for kids. Nana is the industrial partner while Mia is the capitalist. Nana's shift ends at 5 in the afternoon. In the above example, is it possible that Nana would engage to music tutorial after 5 p.m. as part-time? The answer is no. If that's the case, Mia can exclude her from the firm with a right to damage or avail for the benefits which she may have obtained with a right to damage. The last example that we have is the Article 1793. So si Palang ay may utang sa Jading Partnership amounting to 25,000 pesos. So si Palang, na-receive na niya yung share niya amounting to 5,000 ahead of Alvin. So when Alvin collects his share, Palang was already insolvent. So in the above case, Nadine is required to share the 5,000 to Alvin kahit na si Nadine is given a receipt for her share already.
Thank you everyone for having you with us, and thank you for giving us your time to watch our video presentation. I hope that you've learned a lot from our topics. Have a great day everyone, and keep safe.